Good morning, everyone. Welcome to the University of São Paulo Law School. This is a seminar about Sociology of Digital Law, and it is promoted by the Department of Jurisprudence and Philosophy of Law. The seminar, as you all will see, presents some researches that adopted mainly social systems theory, Niklas Luhmann's theory, in order to detect and to analyze contemporary topics such as data privacy, artificial intelligence, and fake news regulation. Today it's a pleasure to have with us again in the law school Professor Hanna from the University of Durham at the United Kingdom, where he teaches media law. Professor Hanna researches on freedom of expression and privacy, with particular interest in defamation law in divided societies and the development of a tort of privacy. He obtained his PhD from Queen Mary University of London, and he is also a co-author of a book that I, Professor Marco Barros, and Professor Celso Campilongo, our head of the law school, we have edited a book on Luhmann and social legal research, an empirical agenda for social systems theory, and one of the chapters of this book is authored by Professor Hanna. I thank also Professor Marco Antônio Loschiavo Leme de Barros from Mackenzie University for providing this opportunity of having Professor Hanna with us again. Professor Marco Barros was a colleague of mine during our PhDs here at the law school, and now he coordinates a research group on law and regulation of society at Mackenzie. He was also a visiting researcher at UCLA, University of California, Los Angeles, and also at the Oñate International Institute for the Sociology of Law in Spain. So we will have in first place the conference by Professor Hanna. He will talk about what is informational privacy, what is physical privacy, insights from Luhmann's communication theory. Then I will say some words about a research that we conducted here at the law school about fake news in Brazil. And finally we will have the lecture by Professor Marco Barros about regulation through risk, a debate on the legal framework of artificial intelligence in Brazil. So, Professor Hanna, it's a pleasure to have you again here with us, and the floor is yours.
Thank you. Thank you, and good morning to everyone. Thank you to Professor Amato for inviting me to speak here. It really is an honour to speak and speak to you all. And thanks also to Professor Barros for the invite again to be here in São Paulo, and also for co-presenting with me. I will speak today then about the subject of informational privacy and physical privacy, and using Luhmann's theory to gain insights into what both of those things mean, what it means when we talk about informational privacy and what it means when we talk about physical privacy. This is a debate in certainly in the United Kingdom and in other jurisdictions around the world, especially common law jurisdictions. This is a bit of a debate that's going on at the minute about what is informational privacy, what is physical privacy, and what should the law do in relation to both of those types of privacy. And I think that Luhmann's theory, his communications theory, is very helpful in helping us to understand that. And I don't think a lot has been said about that, so I'm very interested to talk about that. So I will talk then generally an introduction where I'll talk about what's called the transition model of information or communication, and this is what Luhmann really picked up on and decided to criticize. And I will talk about then what Luhmann's concept of information and communication is instead. And I'll use that then to try to gain some insight to what it is when we're talking about informational privacy and what is physical privacy, and then talking about what this means for law and how this could help us to understand the law better. So, the transmission metaphor of information is that information is something that's passed from one person to another. In the social sciences, that is generally how we have considered information to be. It's something that one person passes to another, so it's almost like some physical reality. Somebody sends information and somebody receives the information. There's something passing between the people. And this was something which Luhmann criticized. He said that when you look into the nature of information and communication, this is not really true. It's not a case that something is being sent from one person to another. But it's been hugely influential. This transmission model of communication has been hugely influential in privacy scholarship, and we have a lot of well-known privacy scholars like Ruth Gavison in the United States who've talked about information as being something that one gains access to, something that's acquired, something that one can construct barriers to. And this idea that really information is passing from one person to another, and if we want to protect private information, then we can build these barriers to stop that. So this is the kind of idea of information that Luhmann was really against, and that he really wanted to develop an alternative concept to. And what he proposed instead was a model of information and communication that's made up of three different parts. And this is actually based on communications theory more generally and mathematics, which Luhmann does. Sometimes he borrows from especially natural sciences. So he looked at cybernetics and he looked at mathematics, mathematical models of communication, and he came up with this idea that information and communication is a three-step process. And it does not involve anything being transmitted from one person to another. So, what Luhmann said is information is always part of communication, and that communication is always the selection of information, the selection of an utterance of this information, and selective understanding or misunderstanding of this utterance and its information. So three different things are going on in communication, like right now. There's a selection of information, and then there's a selection of some kind of behavior to give expression to that information, and then there's some selection in going on in understanding, right? So three different selections happening, three different choices happening between the people who are involved in communication. Nothing is being transmitted from one person to another. I will give some examples of how that works in a second. So let's take the example that the piece of information that someone is going to select is about the news that the president has just announced his resignation. That's a selection of information because the person who chose to speak about that, they could have talked about other things. They could have talked about the weather. They could have talked about the price of gasoline. They could have talked about football. But they choose something out of the horizon, out of all the things that are the information that's out there. They choose one thing and select that as information. So this is what he means when he's talking about the selection of information. This is the first selection that happens in communication. This is the first choice that happens in communication. Second, there's a selection of some behavior to give expression to that information, right? And this is always the case. So if we take the example the news, the piece of information that the president has just announced his resignation? Well, you could communicate about that or express that through WhatsApp in a text message. You could print it in a newspaper or put it on a news website, or you could whisper it into the ear of another person. But it will always involve a choice, and it'll always involve a selection here also. So we have two selections already happening. We have the selection of information. The president has announced his resignation, and then we have the selection of some way of expressing that. We could put it in a WhatsApp group, we could put it in a newspaper, we could whisper it into the ear of the other. So these are the first two selections that are happening in communication. And then the third selection is selective understanding. Now, we usually don't think about understanding as being a selection, or that there's any kind of choice going on when somebody tells us some information. For example, if somebody tells us that the president has just announced their resignation, we think, well, we just understand that immediately. There's no choice, there's no selection happening. But there is selection here also, because if it's if it's communicated, for example, in a WhatsApp group that is between friends, then that's going to be understood in a certain way. If it's printed in a newspaper which you don't completely trust, or you've learned to be skeptical of, then there's some selection going on there. If it's whispered into the ear of the vice president when he's meeting with foreign dignitaries, the president has just resigned, then there's going to be a select understanding about that. So the selective understanding and why that is a choice has got to do with the social situation that the person is in. It has to do with social context, but it's always a selective understanding. It's always a subjective understanding on the person who hears the message, right? Because they have to decide amongst all the social context what it means and what importance they should give to it. So these are the three selections then are happening in communication according to Luhmann. But what we now know, if we accept this model, is that there's nothing being transmitted from one person to another. There's nothing moving from me to you right now. Instead, what is happening is I'm making selections and you are also making selections. And the process is complex and it's contingent. And this is very important for understanding privacy and understanding informational privacy and understanding physical privacy also. So what I have suggested is adopting Luhmann's concept of information and communication and applying it to the concept of privacy. So I argue then that informational privacy should be seen as involving each of these three selections that constitute communication. Informational privacy is also always involves the selection of information that's deemed to be private, behaviour which gives expression to that information, and I don't mean publication, I don't mean putting it in a newspaper, but just giving some kind of choice that gives expression to that information. And then third, some selective understanding that that information is private, or it's a violation of privacy. Right? So when we're talking about informational privacy, we're talking about these three elements occurring, these three ingredients. And I suggest that we can define physical privacy by the absence of any of these selections. So physical privacy can be distinguished on the basis that this does not involve these selections. In cases of physical privacy, at least one of them will be missing. Now let me give some examples from case law, which will help to understand what I mean by this. So this is a case in England and Wales called Gelati and others against the Mirror Group newspapers, and it's got to do with phone hacking. I'm not sure if you've heard about phone hacking, but it's a very big story in England, because what is happening in England is journalists of tabloid newspapers were using phone hacking to break into the phones of celebrities so that they could listen to their messages, and then they would use that to print stories and sell newspapers. And this had happened over some years, and there was a big investigation into it. But it also led to a lot of privacy claims. And in this case, in Gelati, it's been argued that this is one of the cases that involved physical privacy, because there was no publication of the information that they got from the claimant's phone. They took information from his phone, but they didn't put it in the newspaper. And it's been argued that therefore it's a case of physical privacy. But I would say that this is a case of informational privacy under Luhmann's concept of private information, because we have here a clear selection of information that's deemed to be private. We know that because the journalists have to go through this technical process of hacking into a phone in order to get the information, right? And this is why the development of communications technology is making these selections more obvious and important. So we know that there's a selection of information in this case because we know the journalists had to go through that process of getting into the phone. We know that there's a selection of behaviour to give expression to that information. Okay, there may not have been a publication of the information that they got from the phone, but they did give expression to that, because the journalists who were hacking into the phone were going back and forward to the editor's office and reporting on what information they were getting. They were hiring private investigators to go and investigate the information that they were getting from the phone to see if they could get other stories on other people. So there may not have been publication in a newspaper, but there was a paper trail and a data trail that gave expression to their selection of that information from the phone. So we have the first two selections there, and then we have the third as well, because whenever the claimant learnt that his phone had been hacked into, he automatically understood that as being private information, and then later so did the court. So this is an example of what I mean by informational privacy, using this Luhmannian concept of information. This is a New Zealand case. It's another example of informational privacy, but it's been widely reported as being a case of physical privacy. It's a case called C in Holland. And what happened in this case was the defendant shared a flat with his friend, and his friend, his girlfriend would come and stay at their flat for a few days at a time, and of course she would use the bathroom facilities. The defendant installed a digital camera in the roof directly above the shower and set it up to record his flatmate's girlfriend when she went to the shower. He later then did record her in the shower, then went to the digital camera and downloaded the file, and then transferred that file to his computer and saved the file with the nickname of his flatmate's girlfriend. Some time later, his flatmate asked to borrow the computer, and he spotted the file name with his girlfriend's nickname, and he clicked on the file, and then he saw what it was, and he told her, and then it resulted in the court case. Now, in New Zealand, this has been called the first case of a general tort of intrusion. It's been the first case where the New Zealand courts have stepped in and protected physical privacy, and it's meant to be one of these big physical privacy cases. But I would argue actually that this is a case of informational privacy under Luhmann's concept of information. Look, we have a clear selection of the information that's deemed to be private here. We know that because, again, the defendant installed that camera, digital camera, went to the trouble, put it directly above the shower facilities, and set it up to record his flatmate's girlfriend when she used the shower. So again, technology is making these selections more obvious. There's been a clear selection of behaviour to give expression to that information. We know that because he downloaded that digital file from the camera, transferred it to the computer, saved it with the nickname of the girl, and saved it as data in that way. So there may not be publication here again, but there is selection of behaviour that gives expression to that information. And then finally, there's understanding that the information is private, selective understanding, first of all on the part of the boyfriend, then on the part of the plaintiff herself, and then later on the court. So this is an example here again of how Luhmann's concept of informational privacy, or using Luhmann's concept of communication, gives us insight into informational privacy. Physical privacy then, under this concept. Here's some examples of this. There's a very famous case in England and Wales. It's called Wainwright. Well, actually, it should be called Wainwright and the Home Office. It later resulted in a court case going to the European Court of Human Rights, which is why it's called Wainwright in UK there. But what happened in this case was it involved a lady and her son who went to visit their husband in jail. Their husband was in jail for murder, and he was suspected of dealing drugs in jail. And the prison authorities were subjecting everybody that came to visit him to strip searches. And they subjected his wife and his son to a pretty nasty strip search, which involved, they had to be undressed and they had to be physically examined by the prison authorities. And they later brought a claim against the prison authorities saying that they had violated their privacy. And the court, the House of Lords Court in the UK, the Supreme Court in the UK, said there's no claim to privacy here because we don't recognise physical privacy claims. We only recognise claims for misuse of private information, right? And some people have said that this is wrong, but I think that using the concept that I've outlined to you, we can say that this is clearly a case of physical privacy here, right? Because the selections are not so obvious. If we look at, well, is there been a selection of the information that's deemed to be private? We can't say that there has, because what the defendant, what the prison authorities were interested in here was not the naked bodies of the claimants, but rather it was whether or not they were smuggling drugs into the prison. There's been no clear selection of behaviour to give expression to the information that's private here. They did not publicise or film or record the data of the people being strip searched in any way. They didn't open the window and shout at any passerbys, hey, we're strip searching them right now. And then finally, there's no selective understanding that that information is being private. So we don't see it in these type of cases, these selections being made out. Here's another example, the last example I'll give a physical privacy claim. This is a case of Fern and others against the Board of Trustees of the Tate Gallery. It's a very recent case. It was just heard by the Supreme Court in the UK a few months ago, and they handed down their judgment. The case involved a claim that was brought against the Tate Museum of Modern Art in central London. Maybe some of you have visited before, but the Tate Gallery recently opened a viewing gallery at the top of the museum so that the visitors to the gallery could have a really nice view of London. But unfortunately, it was built very close to some luxury apartments, which you can see in the picture. And the thousands of people who were going to the Tate viewing gallery every day were effectively looking into the windows and taking photographs of the interior of the flats in these luxury apartments next door to the art museum. And the owners of those flats then brought a claim against the art museum, saying that they violated their privacy. And one of the things they claimed for was misuse of private information. And the Supreme Court said, no, we don't hear claims like that. We'll allow this as what they call a private nuisance claim, which has got to do with a property interest. But they said there's no violation of personal privacy here. This is not an informational case. This is a physical privacy case. And this checks out with Luhmann's concept, or the concept of Luhmann's concept of communication that I've outlined here earlier. There's no clear selection of the information that's deemed to be private here. If the art museum was interested in anything in constructing the gallery, it was the views to the south and west of London, as they put in their brochure. There's no clear selection of behaviour to give expression to the information deemed to be private here. In fact, the art museum put up notices on the viewing gallery asking people not to look into the flats of the people nearby, not to take photographs, and they put security guards on the viewing gallery to make sure people weren't doing that as well. So here we have a clear case where we don't see those selections on the part of the defendant happening, and we can say that this is a claim of physical privacy in that sense. Why is this important? Well, it's important in England and in some of the common law jurisdictions around the world because, as I said at the beginning, there's a big debate going on saying that the courts in England and Wales and other parts of the world are denying claims to physical privacy, and they should really include those within these claims to informational privacy. And one of the most influential authors in that has been Nicole Moram for arguing that. But I would argue that Moram and others have misconceived what physical privacy is and what informational privacy is, and that when you use Luhmann's concept of communication, it actually gives you some insight into that. So I would argue that if you do employ Luhmann's concept of communication, the insights that it gives you is, first of all, is that there is some discernible distinction between informational and physical privacy. It's not like they're both the same thing. There is some real distinction between them, and maybe there's some functionality to what the courts are doing around the world in making that distinction. And then secondly, that the concept of informational privacy is actually quite inclusive, and it reflects the increasing importance of this type of privacy in society. So it's not like, because what Moram and other people have argued is that the way the courts are looking at this, they define informational privacy and it's only covering a small type of privacy claims, but actually it's very inclusive and expansive, and I think as technology develops, that becomes even more so the case. This is really important as well for sexual privacy, privacy claims, which is a big subject in the United States at the minute. And I think that when you employ Luhmann's concept of communications theory and that kind of concept of informational privacy, it does have some insight into the law and what's happening and how to protect sexual privacy in the law as being issues of informational privacy. And the more that technology is used to make incursions into people's privacy, it should fall within data protection law and informational privacy. And here's an example of deepfake pornography being used against people, and I think that this kind of concept of informational privacy can have some importance there as well. Sorry, I think that was the older slide, but there was a final one there, which is just to say, well, I've forgotten what it was exactly now, but I think that it was just to say that really I think that the virtue or the good thing about this concept of informational privacy is just that we can begin to understand how important informational privacy has become in the world, and it's inclusive and it's bringing more and more parts of daily life into this issue of privacy and allowing for the development of law to capture a lot of these technological issues that are happening, not just with sexual privacy, but just the way that technology in general is encroaching upon private lives and capturing so much of our lives as data and information. Thank you very much for your attention. Thanks.
Thank you, Professor Hanna. I think that we can have a final time for answers and questions, but we can also have some questions for Professor Hanna referring to his presentation now, if someone wants to comment. Se quiser falar em português, você que escolhe. Se você preferir, pode ser em inglês. Mas eu vou pedir quem for fazer para vir aqui para a gente registrar. A gente está filmando lá e para a gente ouvir melhor também.
Só nesse último ponto que foi dito, just on this last thing, I would like to understand if you understand sexual privacy as sort of included in this Luhmann informational privacy concept, or is it just something that's related but not really included?
Yeah, thanks. I think it's really included, which is why I think that that's the important point about, I mean, because a lot of this debate at the minute is that the law is failing sexual privacy and there's more and more technology being used to to violate sexual privacy. And I think that actually Luhmann's concept, if you use this concept of informational privacy, it shows that the law could develop, you know. So for example, in England and Wales, they say, well, we don't protect physical privacy in the law, we only protect informational privacy. But if we say, but this is informational privacy, it is informational privacy if you put a camera above a shower and record that and download it and save it on a computer, then it becomes information. It's not just purely physical anymore, it's information, and the law then should recognize this. So I think that the change in thinking allows the law some confidence to develop and to say, well, we can deal with these type of cases now, and these kind of sexual privacy cases. Thanks.
I'd like to ask about this category of physical privacy and informational privacy, because I haven't heard it here in Brazil, this kind of discussion, and I'd like to ask you if do you think it's applicable to the civil law and our legal system also.
Yeah, thanks. It's a good question. Actually, it was kind of a question that I had for you guys, because I don't know a lot about the law in Brazil, and I think that in civil law jurisdictions it is a little bit different. But I wonder if there are some issues in Brazil about this that are similar, because when I look at what's happening in United States, in England and Wales, in Ireland, in Australia, in New Zealand, these kind of common law countries, this is a really common debate. And there's a lot of, the judges have a lot of difficulty with trying to distinguish between physical privacy and informational privacy. And it seems as if the law wants to protect informational privacy more than it wants to protect physical privacy. And that's interesting from Luhmann's perspective, because why does the law want to protect informational privacy and not physical privacy so much? The Luhmannian answer is, well, because society wants to keep communicating about things. It wants to protect information. It wants to protect communication. It doesn't want to protect physical bodies. And I think that maybe that's a universal thing. So I don't know what exactly what the situation is in Brazil with the law, but I think that if you critically analyse it, you will maybe see that there are some issues there with this distinction and how the law reacts differently to physical privacy than it does to informational privacy. But I asked the question of you. I mean, you guys know more about the law here than I do. What do you think? Do you think that there's some issue here around this? Can you see anything that maybe presents a problem in relation to the law in Brazil? Thank you for your question.
So, throughout your exposition, you said about the role the courts play in the interpretation of what should be considered physical or informational privacy. And here in Brazil, following the civil law system, the courts play mainly a role of, when they set precedents, a role of uniformization of different interpretations of law. So, this thinking should be followed in all the other cases.
Yeah.
So it doesn't really set a precedent of what should be considered as physical or informational privacy. That would be more of a concern for our legislators.
Yeah.
So I think that debate here in the civil law system is kind of replaced to our chambers, so the Chamber of Deputies and the Senate. So I think that's one of the main differences. So who sets the precedent, or who defines what should be protected by the law, and which kind of privacy should have a bigger or a smaller importance when it comes to the judgment of cases like this that you exposed.
Yeah.
So I think that's one of the main differences, and consequently it makes it also different in how bigger or how smaller the importance is, how bigger or smaller importance is given to each one of these realms of this privacy. So
Yeah.
I think that's one of the main points when it comes to the difference between civil law and common law system.
Okay. Yeah, thanks very much. And I think that I should say that, you know, the common law countries, it's not like the judges make law. They don't like to make the law, that, or so they say. They also like to follow precedent, but in this issue of privacy, Parliament in England and Wales has refused to do anything. And the reason they don't want to do anything, it is said, is because privacy is so complex that they don't know exactly what to say about it. So they've left it to the judges to make these decisions. And the judges have made the decision that informational privacy is more important than physical privacy. But that doesn't mean that physical privacy is not protected there. There's other types of actions that somebody can take. You can claim under criminal law, you can claim for what's called battery, which is unlawful touching, and things like that. So there's other remedies, but where we see the law developing faster and the courts making decisions and being quite revolutionary is in relation to informational privacy. But I take the point about Brazil, and it is your legislature who is making decisions about what is privacy here and whether informational privacy is more important than physical privacy or whether they're both equally important. And again, that's a question for you as scholars of the Brazilian legal system to understand exactly that. It doesn't matter in a way if it's the courts or if it's the legislature. It's the people who make the laws in this country, and I think our job as scholars is to try and understand what kind of laws are they making for society and whether or not that's functional for society. Thanks.
Anyone wants to make some additional question now? So, I think that your point has a deep similarity with what I will be saying, in the sense that these themes about digital law that we are discussing today, even if the legislation tries to define some points, try to create some criminal or some administrative types of conduct, there is a huge space for case law, for the judges to see the concrete cases and try to make the distinctions. So it's difficult to create legislation, even if we think that in Brazil, the National Congress would be the competent arena to define this kind of difference between informational privacy and physical privacy. The tendency is to not have a definition of these issues, is to just put on legislation, on the statutes, some principles, and to move to the courts to deep and to analyze the differences, the attributes of each case that would characterize, for instance, physical privacy and informational privacy. So I think that the legal systems are, in practice, much more similar than different in this respect.
On that point, I just wanted to say that Also, the courts, and I should say that the courts in England and Wales, even though they make this distinction, and even though a lot of people criticise them for making this distinction, they don't define informational privacy, and because they don't have to. That's not their job. As they don't use Luhmann's theory to try and understand what it is. They just make the decisions. But for as scholars, when we're trying to understand what's going on and how it relates to society, then I think that's why it's useful for us to use that.
I think I have here. So thank you, Lucas, for putting together this event, and also Professor Mark for presenting a very interesting topic. My question would be, applying Luhmann's theory on the concept of privacy, what are the potential benefits in order to regulate privacy? Because, as you said in your presentation, privacy is a complex concept, and you put it very clearly that in the sense of trying to regulate behavior, when the privacy is violated, actually we can see different agents or different actions actually related with this offense. So my question is, in this perspective, what is the importance of the informational privacy concept through Luhmann's theory in order to regulate privacy? I think that's something interesting to take besides the theory, in order how we can, in some kind of way, operate this through the law. Since, as you mentioned, even the law system has difficulties to distinguish the physical and informational privacy, and I think in Brazil is also the same case. We don't have a clear distinction between informational and physical privacy in our legislation. But we can see in cases here in Brazil this necessary distinction, especially in torts.
Yes. Yeah. Well, Professor Barros asked a very important question. He asked, what's the point of making this distinction? Which is a great question. Well, first of all, I think that the reason that I became interested in this, because what's happening in England and Wales is a lot of people are criticising the courts for what they're doing and saying they need to develop a general tort of intrusion that includes both physical and informational privacy, but the courts are not listening. And the recent example of the Tate Gallery case in the Supreme Court was another example of them just saying, well, we don't care about that argument. And I'm saying that, well, if we employ this Luhmannian concept, we kind of understand, hang on a second, maybe there's what the courts are doing is functional and it's not all bad, and maybe we can't, because privacy is a very complex, if you take both physical and informational privacy in general, then it becomes very complex. It becomes hard for judges to deal with, it becomes hard for legislators to deal with. But when we kind of cut it down and say, listen, there's this thing, it's called physical privacy, and there's this thing called informational privacy, it maybe makes it more manageable for the law to be able, for legislators or for courts to be able to say, let's focus on this and find a special law for this, and let's focus on this and find a special law for this. And that is actually, I think, what the courts in England and Wales are doing. They're not holding their hand up and saying, this is what we're doing, but this is kind of what you can see that is happening. So what's the point of this? I think that it helps lawmakers to break this difficult subject of privacy down and be able to concentrate on developing maybe two different bases of law in relation to these two very different types of privacy.
I will make a question that may be of interest of everyone, which is, is this an ongoing research? Have you published some paper on that subject that we could read, that we could refer to?
I have submitted a paper to a journal on this. I'm waiting for the reviewers to to give me the tick to say it can be published. So, fingers crossed.
Yeah. So we wait the publication in order to have more details and to engage with your paper in researches here at the law school and about Brazilian law also. I will move to present some brief words about the research that we conducted here at the law school with the support of FAPESP, São Paulo State Research Foundation. We have conducted research on fake news in elections in Brazil with Professor Celso Campilongo, Professor Marco Barros, Diana Saba, and Paula Ponce. And this topic of fake news regulation, as we all know, have become a trend topic this year. So our research focused on the elections of 2018, but today we see the difficulty of approving a statute to regulate the fake news. So I want to say some brief words, also connecting the evidences that we got on this research with the news from today, from these months, and using also Luhmann's theory. Professor Hanna just presented a very creative utterance of Luhmann's theory, applying his concepts of information to analyze case law concerning data privacy. And I will use some concepts from systems theory in order to try to analyze the conflict between politics and law in Brazil and the frictions among political and legal system in trying to regulate fake news. So my team is legal innovation and regulatory learning, evidence from fake news regulation in Brazil. The phenomenon of massive dissemination of misinformation through digital networks, what the semantics of our time has marked by the term fake news, has gained notoriety in the last decade around the world. Political events that have highlighted this strategy, that has mobilized the functions and dysfunctions of digital platforms, include the scandal of personal data breaches on social networks by the company Cambridge Analytica, hired for campaigns favoring the election of Donald Trump in the United States in 2016. Also, Cambridge Analytica was hired by pro-Brexit groups in the United Kingdom in 2020. And these strategies have spread around the world. And here I want to say some words about the Brazilian case. Brazil has been preparing a kind of regulatory package for digital communications since the Internet Bill of Rights in 2014. And as the scandals of personal data breaches in digital environment emerged worldwide, the general law for the protection of personal data was being processed in the Brazilian National Congress. So this law, the LGPD, was the subject of intense dispute. The statute was approved by the National Congress in August 2018, on the eve of the October presidential election, which marked a new level of mobilization of digital networks by electoral campaigns, especially for the dissemination of fake news. However, the president-elected, Bolsonaro, and his parliamentary bases were notorious beneficiaries of these strategies of orchestrated disinformation and misinformation. So political disputes postponed the start of the law's effectiveness to September 2020, so 2 years after the approval of this statute, and the administrative sanctions provided by the law only became enforceable in August 2021. Just to remember, so 3 years after the approval of the law. This kind of temporal postponement of the effectiveness of the law shows how it is a subject of political controversy. And the fake news draft bill that we are discussing today followed a similar course because it began to be analyzed after the 2018 elections and was approved by the Federal Senate in 2020. But the expectation of having it approved for the elections last year in 2022 was frustrated. And now, in the middle of 2023, the President of the House of Representatives, as we all know, still has not managed to get the approval to put the project to vote. He has not guaranteed a favorable quorum for the proposal that has been debated for so many years in the legislative branch. And it is worth noting that some events began this year of 2023 with a strong presence of digital networks as environments for mobilization and expression of extremist discourses that overflowed the virtual world. This is the case of the terror, the invasion, and the vandalization of the main buildings of the Brazilian state in Brasilia during the 8th of January, and as well as this is the case of orchestrated attacks, violent attacks in school also this year. So this is the scenario in which fake news regulation is still being discussed by our parliament. And in light of this brief legislative history, it's important to point out to 4 regulatory strategies that can be identified from the interaction between these legislative initiatives and other regulatory arenas, the judicial branches and the parastatal, the private legal orders created by the digital platforms themselves. This team reviews a challenge for the learning of the legal system, for the regulatory learning of the legal system, for at least 3 reasons. From a social perspective, fake news is a phenomenon with repercussions in multiple areas of society. Not only politics, electoral fake news, but also fake news concerning healthcare, education, science, religion. So this is a kind of complexity of regulating this theme. We have another complexity in terms of time, because this is a novelty, not only in terms of the technological evolution of the digital platforms, the social networks, the private messaging services, but also due to the exponential process of digitalization of communications in society, as we have seen since the coronavirus pandemics. So every communication nowadays is produced by digital means of dissemination. And this characterizes the risks of fake news through these digital platforms. And finally, the issue involves technologies under the transnational dominion of global monopolies and oligopolies, thus posing challenges to the scope of state national law to bring national regulation to global platforms. So, as we have seen, facing these challenges, we notice 4 regulatory answers that the Brazilian law is trying to produce in order to start regulating fake news. The first regulatory strategy is the focus on principles, the reliance on principled norms instead of on the definition of rules with clear hypotheses of incidence and due consequences. This use of principles instead of rules allows for greater adaptability of the legislation to technology, and also informs the creation of legal microsystems, legal areas of speciality that evolve and become more complex, as we just have seen an example here in the presentation of Professor Hanna. The example was how to distinguish physical privacy from informational privacy. So new sub-areas, microsystems are created, and principles have the potential of generating this kind of complexity in the legal system. But also, the indeterminacy generated by principles also produce uncertainty about which conducts are illegal, which sanctions are applicable, and when this will in fact be defined by legislation, by case law, by regulatory authorities. The definition of principles tends to transfer discretionary power to administrative authorities or, in their absence, directly to the judicial authorities, overloading the judiciary branch. In the Brazilian case, the suits before the Supreme Federal Court and the Superior Electoral Court stand out in this respect. And this operational overload of courts occur whether in terms of their technical knowledge and the speed of response to the events that are occurring day to day, and also this is an overload concerning the judicial legitimacy to take decisions that are not backed by pre-programmed rules, by decisions sustained by the political branches. So if a judge decides a case having a clear base in law, in statutes, he has a lower need of legitimacy to decide that case. If he needs to decide some case not having a clear rule to apply, he's putting his political legitimacy in the front to be judged by the public in some respect. So this is the first regulatory strategy of dealing with this kind of theme, the use of principles. The second legislative strategy is what we could say cognitivization. That is, although law is reproduced especially by norms, normative expectations that are counterfactual norms which are reinforced by procedures and by sanctions, norms may gain a high factual density, a high dependence on evidentiary and proof issues, on matters of fact, of proof, and on expert knowledge. So in the regulation of digital communications, this expertise concerns highly changeable definition of information technology, which is dominated by experts and by global companies, and also protected by their intellectual property. So it's difficult to the state to have, and to the judges to have access to the details, to the technical and technological details of each technology, of each digital platform. So there is an opening of the law, of the rules, of the ratio decidendi to the expert knowledge in IT. The third regulatory strategy is peripherization. What is peripherization? In terms of social systems theory, the legislative branch is at the core, at the center of the political system, because the legislative is the organization, is the branch of the state which takes collectively binding decisions. But at the same time, the legislative is at the periphery of the legal system, because it just produces general rules that will be applied, will be interpreted by courts. The courts have the last word to say about concrete case, so the judiciary branch is at the core, at the center of the legal system. Because the judiciary branch is constrained by the prohibition of non-liquid. So, in the absence of legal definitions, in the absence of well-defined rules on these topics, the judiciary awaits for the legislative definition of the types, of the concepts, what is fake news, for instance. But the legislative, which is at the core of the political system, which has the competence, the power, the duty to take collective binding decisions, also refers to the periphery of the political system, where it finds not only the political parties, but also the academics, the experts on information technology and on digital law, the social movements on internet and on digital law, and also the interest groups, including the digital platforms lobbies. So in fact, many norms that are proposed after a process of hearing these kinds of agents on civil society. Not only the regulatory difficulty of the new technologies, but also the search of support outside the state mark this opening to civil society participation, to hearings of lawyers, of lobbies, of digital platforms representatives, and social movements in this theme, in this topic. And finally, the fourth regulatory strategy, besides using principles, besides using norms opened to questions, to matters of fact, besides referring to the knowledge from civil society, the fourth regulatory strategy of Brazilian law is identified with the term proceduralization. That is, state law moves to recognize the self-regulatory instances of digital platforms, but also to institutionalize an opening to these other sources of law, to the non-state orders, but also imposing some limits to self-regulation. Recognizing that digital platforms have developed their own instances of content moderation, either to solve problems with speed and technology, that is dominated by the digital platforms themselves, or by they develop these self-regulatory strategies to build a kind of shield against state intervention in those teams, in defining what is according the rules of that social media, for instance. The fake news draft bill in Brazil incorporated the concept of regulated self-regulation. So, recognizing that there is self-regulation, the idea was to create limits to regulate self-regulation. The initial idea was to create an independent digital communications regulatory agency or authority of mixed composition with representatives from the state, from digital platforms, from university, and from digital rights movements. And this kind of regulated self-regulation or co-regulation instance would be an important learning instance for law, capable of keeping up with technological evolution, with a more detailed regulatory evolution, more technically based, and more easily changeable than legislation. The idea was that the definition of rules was not meant to be made by legislation, but a long time by these independent regulatory agents. But now we have seen the recent controversy in the beginning of this year that prevented the construction of a consensus in favor of the approval of the fake news draft bill here in Brazil. And the version of the bill that was ready for voting removed the provision to create this independent regulatory agency with expertise and shielded from political and from economic pressures. Thus, the statute would be instituted without the crucial device for regulatory learning and for the enforcement of its rules, its principles and its sanctions. After all, such entity should be the articulating node of a network of regulatory and self-regulatory layers, At the same time, it would have a reinforced autonomy, unlike a mere body of the executive branch, like an organ subordinated to a state ministry. The creation of procedural and organizational norms allows the institutionalization of learning for new teams which law has not yet been able to discipline more thoroughly. Now, we can sustain the hypothesis that while this type of regulatory agency is not institutionalized, what we will see is what we have now. On the one side, conflicts among the political powers of national basis and democratic legitimation, the judicial branch, also nationally based and responsible for upholding the rule of law, and the global digital platforms which seek to escape the costs and risks of their profitable business. While there are no regulatory learning organizations and procedures, as in the current scenario, the issue of fake news will have to be dealt with discretionary measures, with monocratic and coercive decisions of judges, until the consolidation through statutes, through case law, of normative guidelines and rules and procedures, including procedures of coordination among the branches of state and between state and private platforms. On the one hand, in the political system, we see the proliferation of associations, and at the heart of the legislative branch, we observe the formation of different parliamentary benches, including a big tech bench. There is some deputies, some representatives that are directly pressured by the big techs. On the side of civil society and public opinion, there is a series of conflicting demands. The reactionary political group tries to despise the independent regulatory agency, pejoratively calling it the Ministry of Truth and evoking the fear against censorship. On the other side, to curb the actions of fascist digital militias, some justices at the Supreme Federal Court defend equating the responsibilities of digital platforms to those of firms of mass media and advertising companies. On the other hand, established regulatory agencies such as the National Telecommunications Agency or the Internet Steering Committee fight to assume the functions related to the monitoring, supervision and punishment of fake news. Progressive groups try to impose identity politics agendas to define what can or cannot be said on digital platforms, and the creators and companies take the opportunity to reinforce their copyright protection agendas. Finally, we have some political and religious leaders that worry about the real effects of hate speech propagated by digital media. So there is a confused network of interests, of topics being discussed, and this is an explanation why we didn't get the approval, the voting of this project about fake news. While this tangle of lobbies and movements, interests and discourses orbited the discussion of the bill, some digital platforms promoted an intense campaign against the vote of the fake news bill, sending mass messages to their users, disseminating fear and concern about their freedom of expression in order to mask the platform's own concerns with costs and possible reduction of profit conditioned by the new regulatory mechanisms proposed. And the Federal Supreme Court itself, by determination of whom investigations on fake news and digital militias have been conducted for years, has determined the investigation of such platforms for fake news about fake news regulation. So we are at another level of fake news about the regulation of fake news. And taking advantage of the gain of preventing, at least temporarily, the formation of the necessary support to pass this statute, the parliamentary bench, supported by big technology companies, started to submit proposals for changes and amendments in the bill to reduce the margin of accountability of the big techs, and also to protect the parliamentarians in their posts against removal requests. On the other hand, the digital platforms themselves are moving towards accepting a multi-sector and co-regulation agency in order to punish and to define the balance between the misuse of digital networks and the preservation of freedom of expression. Even if the bill is soon approved, we cannot expect the end of disputes, because we can still foresee an extensive and intense regulatory battle about the infra-statutory, the infra-legal definition of substantive organization and procedural rules. The function of the political center, the legislative power above all, would be to channel this dissent procedurally, ultimately managing to achieve the approval of an effective and efficient law. In the end, the legislative function implies defining legitimate objects and subjects of regulation and mobilizing the means, the rules, the sanctions, the procedures in order to have the fulfillment of the goals of this statute. But while the political system does not fulfill its function to take collectively binding decisions, the legal system is overburdened. The judicial core of law, particularly the higher courts, particularly the Supreme Court, are forced to make ad hoc decisions directly confronting digital platforms without having the backing of appropriate legislation. And besides the difficulty of ensuring consistency of law and building a case law capable of binding and guiding future decisions, this type of movement ends up inflating the law itself by deciding without sufficient regulatory and legislative basis, which would manifest a corresponding political support, the judiciary devalues the strength of the law itself, making spontaneous compliance scarcer and having to resort to more overtly coercive measures and threats and punishments, which ends up feedbacking this polemic. There is the lack of support of a regulation of this topic, decreasing again the chances of consensus building around regulation of digital communications. So, while regulatory learning is not institutionalized through legislation, through a co-regulation agency, we see a vicious circle of anomie and impotence, of deauthorization and delegitimation of any strategy and measure to deal with the risks of digital communication, while the dangers of digital communication grow in this kind of digital state of nature with its exponential potential of viralization and production of real, massive and diffuse damages. So this is the situation where we find us today. We don't have the consensus to build regulation. The judiciary is called to take ad hoc decisions, coercive decisions, and this kind of decisions ends up diminishing the support that would be needed to approve a legislation. So we are in a kind of vicious circle of delegitimizing any attempt to regulate this theme. These are some words about this research that we have conducted some years ago, trying to bring it to the contemporary days. We have published a book which is an open access book, which is called Fake News e Eleições, estudo sócio-jurídico sobre comunicação digital e regulação no Brasil. Então é um livro aberto que todos podem acessar. Bom, now I can open some questions, some comments about what I have just said on fake news, and then we pass the word to Professor Marco Barros to say to bring his lecture about artificial intelligence. But we can have some minutes if someone wants to make any comments about this topic of fake news.
Where can I find this book? Where can I find this book?
Google. You put our name on Google. The title of the book is Fake News e Eleições. Editora Fi. Editora Fi. It is on the website of Editora Fi, and also on academia.edu, academia.edu, you can find and download the full book. And there you find the complete research.
I have a comment, if I may. I will first put it in Portuguese and then I will translate. Okay? Acho que do ponto de vista da sociologia do direito, é curioso a gente observar que esse pacote regulatório vem sofrendo ataques políticos de diferentes agentes, né? Acho que o Lucas deixou isso muito claro na exposição. A Lei Geral de Proteção de Dados, por exemplo, demorou alguns anos para de fato entrar em vigência no nosso país por questões eminentemente políticas, né? Daqui a pouco eu vou falar do anteprojeto da regulação da inteligência artificial e também vem sofrendo ataques políticos, né? E o interessante que ficou claro na apresentação é que as próprias plataformas digitais assumem posições políticas contra esse tipo de regulação. Então, um comentário, enfim, que eu queria fazer para o Lucas, não seria o caso de a gente tentar entender, do ponto de vista sociológico, afinal de contas a gente não está preocupado com a solução do caso, mas a compreensão do caso, de entender quais são as motivações políticas por detrás disso. Enfim, então você comentou, evidentemente, uma violação para o debate público no momento em que se discutia ali a possibilidade de aprovação desse projeto. As plataformas digitais, sobretudo o Google, acabou removendo do seu buscador todo o debate a respeito desse movimento legislativo. E aqui um contexto importante: a gente sabe que um dos incentivos que marcou a retomada e a urgência da aprovação desse projeto de lei foi justamente semanas antes os sucessivos ataques às escolas que aconteceram, perpetuado muito por, enfim, em alguma medida, publicações nas redes sociais, engajando as pessoas para, enfim, atacarem as escolas, né? Então, será que a gente está aqui se preocupando em compreender como que a politização, digamos assim, das plataformas digitais estão operando? Então, acho que esse seria o primeiro comentário. O segundo é o quanto que essa politização das plataformas digitais está vinculada também a um outro processo, que é a economização, né, ou a dinâmica econômica, né? Enfim, do ponto de vista sociológico, é interessante a gente observar a integração desses sistemas, e que muitas vezes não está falando sobre o direito, mas está falando sobre a política e a economia, né? So just to translate a little bit,
you can give me the short part.
Yeah, I just asked Lucas that isn't it the case for us to discuss the politicization of the digital platforms, since they are working in some way against the regulation? So the important example that we mentioned was Google, in the process of debating the bill, blocked in the search engine mechanism the discussion for the public. So what is actually the political interest? And another related issue is, from this systemic perspective, is this also an economic issue related with the regulation? So just to outline a bit.
Of course, I agree, and I think that to understand the political motivation of the platforms and relate this political motivation to its economic power, we would need to compare what strategies they have adopted in other countries that are trying to regulate or have also regulated this kind of issue. Because when we started our research, we had this project of comparing Trump election in the United States, Brexit in the UK, and the Brazilian election of Bolsonaro, how these similar contexts motivated and constrained also the discussion about fake news regulation. And now I think that we are in the middle. This is a kind of novelty for us to have the digital platform so explicitly taking positions in favor or against a legislative bill. So I think that we would need to compare, to seek for examples of another countries to understand if there is a global strategy of the digital platforms, or if there are some movements that they take only in some countries, adjusting to the local circumstances and to the different legitimacy of the state in each country. So I think that this would be a good point to make some comparison to understand if there is a strategy or just some kind of pressure in local circumstances. Please.
I ask just a follow-up question, which I think is connected with Marco's question. Well, thanks for the very interesting...
no, there is that.
Oh, there it is.
Yeah.
I think that you really touched on something when you said about regulation of self-regulation. There's something of a paradox here in this area globally, which is very difficult. But what I wanted to raise was the point of, if you do call it political speech, if what Google is doing, then that deserves also a very high level of protection. There's a danger in that, because then Google, if they are speaking politically, maybe they have a right to speak politically. And I just wanted to play devil's advocate a little bit, because when you were talking, you said that the main beneficiaries of the old law and the old way of doing things was Bolsonaro government. And I wonder if people in Brazil are aware of the danger that now you have a different government who maybe wants to see this legislation change, and that there may be some danger of censorship in that regard, even though you can say, well, maybe you don't agree with Bolsonaro kind of government, but there's a tricky question about whether we should allow any government to determine what is fake and what is true when it comes to political speech, because when around the world political speech is meant to be like, well, that's the most important speech there is because it has to do with the public debate and everything that's important. So I wonder if there's any awareness of that danger about censorship, even if you don't agree with Bolsonaro and that kind of politics.
Yeah, I will answer, then I pass to your question. So 2 points. I think that this danger of censorship, of preserving freedom of expression is the real flag that the digital companies show to the population. But the fact that we can observe is that without any regulation, there is an increased risk of taking censorship measures by any judge in Brazil, since there are no legal parameters. So it's difficult for people to understand that someone will have to decide the cases. If we don't have an independent regulatory agency, we may have a department at the Ministry of Communications, which would be worse. If you don't have legislation, you will have case law on this topic, because the problems are going to be brought to the courts. So I think that this kind of understanding is not spread in the population. That's the things will not be total freedom of expression if we don't have the law, and the law will legitimize censorship. Without the law, we will have censorship without having tools to face arbitrary measures, because we don't have how to see if this is an arbitrary measure or it's just an ad hoc decision that was made in some circumstance to prevent some harm, some orchestration of an attack in a school, or a political attack, or coup. So I think that without legislation, there is more danger of attacks on freedom of expression. In this kind of argument, I see that is kind of absent from the public debate. In concerning the companies, I think that we don't have a case law very specific about which of the fundamental rights, of the constitutional rights, such as freedom of expression, and we would place political freedom in this field, which of the constitutional rights we apply to companies, to juridical legal persons, and which of them are only due to natural physical persons. The text of our constitution is meant to have as destinataries the individuals, the physical persons, but jurisprudence tends to extend some fundamental rights, some constitutional rights to companies. But I think that we didn't have a debate yet about freedom of expression. What are the limits of freedom of expression in the case of companies, of economic agents? We have about private property, for instance. All the assets of a company are protected because there is a fundamental right of private property. But we don't have this discussion yet about freedom of expression concerning business. I will hear him and then you. Por favor.
Eu faço a pergunta daqui ou vou até aí? Não sei.
Melhor, pode ver.
Good morning, everyone. I'm Lucas. I have a question which is intended to the three members of the bench. Professor Marco, he mentioned the issue of politicization and how these companies, these tech companies, they are trying to meddle with political affairs. So my question is the following. How do you establish mechanisms that prevent these companies from doing this kind of activity? Because we have a very huge problem, which is the following. They are very powerful, they are very rich. Most of their headquarters are located in a foreign country, which is the United States. And the United States is a country which likes to protect their companies. They're very protective in this sphere. And how do you deal with this huge disparity of influence, of power? I mean, in a few days, for instance, we had this the case of Meta, which is Facebook's parent company, being fined by European Union, and they just fined them like $3 billion. But when you look at their profit, the revenue in the last year was like $116 billion. The fine is big, yes it is, but compared to their revenue is nothing, it's minimal. So how do you establish mechanisms to deal with this fact? Thank you.
Just a comment, then I will pass to you too. I think that we observe in practice two strategies of dealing with these companies. One strategy is like cooperation, bringing those digital platforms to meetings with the Superior Electoral Court, with the Supreme Court. There is a kind of intent of cooperation, but some platforms do not want to cooperate, like Telegram in Brazil. And then we have overtly coercive measures against those platforms that are not so cooperative. And I think that, I don't know, I am commenting just to pass the word for, to Marco, especially on this point, because I think that maybe competition law in Brazil could develop a subsystem, a kind of regulatory process for digital platforms, because we have a competition law under which maybe some conducts of the digital platforms could be analyzed and punished. So I don't know if CADE if our regulatory authority is able to deal with regulatory platforms with the specific kind of conducts that they perform. But I think that competition law would be a more effective answer to deal with a part of the economic power, this kind of economic pressure and political pressure that those platforms conduct and perform in Brazil also, as in other parts of the world.
Well, I'll just say something very briefly before I hand it to Marco, but I wanted to say, first of all, in the United States, you know, they have a very different idea about freedom of expression than the rest of the world. In the United States, they more or less allow everything to be said. And I think there is something to be said about applying that model around the rest of the world, because we maybe don't feel the same in different countries. And I think that there is a question about the special context of a local place, Brazil or England or Northern Ireland. There's always going to be special considerations. But I also think that it's tricky and it's difficult because we're talking about freedom of expression, and these companies, maybe they don't have a right to say things, but people have a right to hear things. So it's not just that their companies, there's also natural legal persons who have a right to hear things as well. And I think that there's really difficult questions about freedom of expression generally, and about what the special needs of the local place is in relation to that.
Okay. So I don't have an answer. I'm just a legal sociologist. I'm sorry to answer this, but I have some perceptions that I could share. And first of all, I believe this is one of the most important topics in our world today regarding legal regulation. As Lucas mentioned, I think one perspective is to observe that this is a problem regarding the economic system, particularly the abuse of economic power. So yes, I guess it's right. We should be discussing the importance of competition law in this area. But I don't think competition law will solve the political aspect of this debate. And I think Mark pointed out very clearly, does Google has the right to express itself as in political terms? If so, what are the legal foundations for this, right? And then we can go back on the idea of citizenship. You know, is Google a Brazilian citizen? I guess not, right? And I think this is something that we should could consider a bit. Another issue is that these are global companies, so perhaps they can apply different strategies in the operations of their their transaction worldwide. Perhaps the strategies in Europe is very different in South America and very different in North America. And in some way, I think this can be explained to the point that Mark mentioned, that the fact is that law and the legal system operates on cultural basis. So the understanding that we have of freedom of expression in Brazil is very different from the US, it's very different from Europe. And in this sense, these tech companies, they are, let's say, very adapted from this cultural difference, and they know how to operate this. And they operate this in terms of profit, I think in the market this is okay. But when we talk about public interest and also in political aspect, I guess this starts to be more complex. And today the fact is that we lack of legislative, of legal framework in order to guide us in this discussion. So I agree with Lucas when he mentioned that perhaps the worst scenario is that we don't have nothing, a parameter in the legal, and everything is open for debate for the judicial system to decide. So I think this is the scenario. Perhaps we have to distinguish what is the political aspect, what is the economic aspect, and what law can, in some kind of way, normatize. So this is the description of the situation.
Hi, it's a pleasure to hear all the speeches, and I'm going to say something to add complexity, and maybe it's more dogmatic for Brazilians than sociological terms. I'm studying a lot the strikes against schools and creches. I forgot the word in English, sorry.
Nursery or creche, yeah.
And an institute from Brazil, o Instituto Sou da Paz, just released a report that analyzes all the strikes against the schools in Brazil. And in this report, it's very clear that, first of all, a kind of profile, and it's also released to the hate and the Nazi Brazilian cells that appears. And it's released too that the use of the platforms in communication, because it was organized and incentivized, and it's a special kind of crime too that goes to repetição, não, mímica, to
Mimic, yeah,
mímica.
mimic, yeah.
Yes.
Yeah.
So we have this situation in Brazil, and it's complex, and it goes to my more dogmatic aspect, because in LPG we have the Article 19 that goes to a responsabilidade subjetiva em direito civil, but the government just released a portaria that goes to direito do consumidor, consumer law, that goes to quando uma coisa tem vício e daí ele aplica responsabilidade objetiva. Então a gente tem hoje, we have today a kind of a shock in the ways that we choose our legal system. Are going to choose direito civil or consumer law. My question is about this scenario.
Please. Well, I will just, first of all, I think that this is a very worrying trend, and it's terrible. And surprisingly, it is not covered in the news that much in Europe. I don't know why, but I will only say that, I've talked about freedom of expression, but there's never a right to freedom of expression if it involves hurting somebody else, and especially when it comes to children. I think that the law really needs to do something about that kind of situation. And I do accept that the social media platforms have some responsibility in this. If they are in any way promoting it, not that they intend to, but if it allows this kind of behaviour to happen, I think that this is where government and the law has to step in and to address it.
Just to be very quick with the answer, I guess today the main argument for digital platforms is to be accountable when they deny judicial orders to remove certain posts or some publications, and this is perhaps today concerning what we have in our legal system. The dogmatic is the mandatory. They are obliged to remove their publication when we have a judicial order. Is this sufficient in order to prevent, the politicization of digital platforms? I don't think so. So, in terms of accountability, that was your question, we have only this perspective of the mandatory obligation to remove the publications with the judicial order. But without judicial order, there is no control, despite the fact that it depends on, the self-regulation of the digital platforms. This is the general picture today when we use actually not LGPD, our general data protection law, but our Marco Civil da Internet. So, Marco Civil da Internet is a very important act in order to prevent this situation, but it still depends on the judicial orders.
Sorry.
Just to add a comment to your question about this conflict between consumers law and civil law, private law, we see the same kind of problem of don't having a regulation statute specific for digital platforms, for fake news, for instance, when Justice Alexandre de Moraes, for instance, he defends that the responsibilities, the liabilities of the digital media companies should be equated to all media, to enterprise of TVs, newspapers. This is another example similar to yours about we don't know which legal treatment we would apply to these companies. The treatment of media companies, mass media companies in general, is treating them as under consumers law, is under civil law, is under constitutional rights. The lack of a specific legislation in this sector leads to this confusion. So if people don't want to take the risks, the dangers of this confusion, of having different treatments of each case, justices issuing different measures in similar cases, we need to get some consensus, to build some consensus, to have a kind of basis of statute to base these conflicts, to solve these conflicts in first hand. Okay, I will pass the word to Professor Marco Barros then to discuss the last topic of our intent here, to bring a sociological discussion about digital law. We have discussed informational privacy, then fake news, and now the trend topic of artificial intelligence, how artificial intelligence is being planned, the regulation of artificial intelligence in Brazil. So thank you again, Marco, for being here and for helping to bring Professor Hanna to this section, to this seminar today.
Thank you, Professor Lucas. It's my pleasure to be here, and I hope to be brief because this is an initial phase research project. Actually, what I will present today is a debate regarding the connections of data protection and the artificial intelligence framework that we are discussing in our Congress. And of course, I will present a sociological perspective based on Nicholas Luhmann theory, mainly when we try to understand the concept of risk. The main question that I would like to address is how to understand the relationship between data protection and the regulation of artificial intelligence. For sure, there are some reasons that we have to understand that there is no necessary relation with data protection and artificial intelligence regulation. I will just put out some arguments. So first, the idea of personal data protection is related with the defense of processing data information regarding individual person, and this doesn't relate necessarily to artificial intelligence. Second, from the legal point of view, the main debate is to define what is artificial intelligence. And in short, artificial intelligence is not actually a right, but is a model of, in some way, operate information in our society. The fact is that many AI systems, they do operate information, personal data. So this is where the connection between data protection and AI systems they start to highlight. And the solution that is on debate our Congress now is that in this connection it is important to promote what the Congress says, the risk-based regulation. And my argument here is simple. In one hand, in order to understand how effective data protection is in our country, in some ways depends on this regulation. We depend on AI regulation since different companies use artificial intelligence to operate personal data. However, the idea of risk-based regulation is not very clear in the anteprojeto, in the bill proposal, and in this sense I will apply Luhmann's concept to discuss how risk generates more risks inside the system. And basically what I'm trying to discuss here is that perhaps one difficulty is trying to make a distinction between the risk towards the development of AI systems vis-a-vis the risk towards the use of AI systems violating law or violating rights. This distinction is not very clear, and in some ways this distinction depends on what Lucas said in his presentation of the cognitivation process, or in other terms, we depend on experts to define what is the risk towards the development of the technology and what is the risk towards the rights. And regarding this discussion, one important topic that I will just mention, I will not comment today, is who is the authority to define this? Is the society? Is the tech companies? Is the legislator, or an independent agency? So this is the scenario that we are dealing with. In my presentation, I will address three issues. The first issue, I will talk a little bit about the data protection culture in Brazil. The second, I will mention about the idea of risk-based regulation in the bill that is in the Congress now. And in my final remarks, I will address a little bit about risk theory and the perspective of Luhmannian insight toward this discussion. So let's talk a little bit now about data protection in Brazil. I believe everyone here in this room knows about Lei Geral de Proteção de Dados, or if you can translate, our Data Protection Act. It was an important legislation that was put into force quite recently. And in this context, recently in the last year in Brazil, we actually amended our constitution, and today is a fundamental right, the right of personal data. Perhaps the most important aspect from the sociological perspective when we debate data protection in Brazil is to understand the effectiveness of this legislation. And so the main question would be, did Lei Geral de Proteção de Dados, our Personal Data Act, truly transform the relations between individuals and companies? This is an open discussion in our society. First of all, perhaps it's still recent to try to understand the facts, because we are talking about 2-3 years of effectiveness of this legislation. But one interesting aspect is that if we analyze this legislation, we will check that there is no sufficient legal instrument that controls the operation of artificial intelligence systems that manipulates, that operates data, personal data. And in this sense, perhaps if we empirically observe that the most significant cases of violation of personal data in Brazil are provoked by artificial intelligence systems, we can at least in an exploratory terms question the real effectiveness of Lei Geral de Proteção de Dados in our society. Some examples, some important examples that we can mention is the strategy of several companies today producing profiles. You know, profiles in terms of economic relations, profiles in terms of political relations, and the use of this information, of this personal data, is not very clear. How these profiles are constructed, how they are built. And the simple answer, to stay in time, is that they use algorithms that easily match and operate different information that is spread out in our social network. So this is interesting because from the sociological perspective, we are concerned about the effectiveness of acts of law, of legislation. But at the same time, some legislation do not tackle the main issues of the problem, and it seems that this is one of the most important cases when we try to connect artificial intelligence and personal data. So the second argument is, okay, there is a new debate going on in Congress about the framework, the legal framework of artificial intelligence. Does this legal framework deals with the problem that I just mentioned? Does it deals with the situation regarding the offense, the violation of personal data? And the solution that the legislative is indicated that it will be addressed based on the idea of risk. This is interesting because the legislator is trying to operate what we call precautionary or prevention principle, and this principle has two main dimensions. The first one is that the regulation have to be broad enough to affect all actors potentially involved in the implementation of certain technology. So everyone is in part responsible of the technology. The second one is the fact that in terms of responsibility, perhaps we have to discuss the concept of risk. So in order to discuss the concept of risk, the legislator presents the idea of risk-based regulation. The question is, what is risk-based regulation in AI? So, from an economic perspective, the legislator deals with the following scenario. Making AI system available in the market
should be necessarily preceded by the presentation of concrete guarantees that they are safe technologies. They are tested, they are stable, and that the system they have undergone prior impact analysis. In this sense, the solution that our Congress is putting out is that in order to an AI system operate in Brazil, it should be analyzed prior the entrance of the market. Something what we could call a preventive control or an ex-ante control. In this sense, the damage must be anticipated and prevented by regulation. Then, the second measure that the bill proposal present is how does the AI draft in Brazil define risk-based regulation? And this is where the issue starts getting more complex. First, the legal definition of risk of AI is a definition by standard, especially by a list of what are the safe applications and what are not the safe applications regarding the industry. Second, AI regulations are risk-based and are risk-based enough in the technology perspective or also in the legal perspective. So there is some difficulties when we are trying to understand what kind of risk we are dealing with inside this legal framework. Just to put out clear some difficulties that are not being addressed at this moment in the draft. First of all, who would have the authority to classify the risks? Second, is it reasonable enough to classify the risk level of UI without having to develop that technology? This is interesting because we are talking about prior control, not a posteriori. Perhaps we could say that what they are trying to present as risk-based regulation would be a sandbox regulation. For companies, wouldn't this be just a merely legal compliance or what we could call a risk compliance? So there are a lot of questions regarding what we understand as risk-based regulation. But for me, perhaps the most important question is to differentiate the situation of the risk of technology and the risk towards violation of rights. And I think this discussion is very important to mark, and especially in sociological terms. So this is where I go to my sociological argument. When we talk about risk applying a systematic view, we have to understand the meaning of risk. We will always be contingent and structurally dependent of the system, of the functional system. So when law talks about EI risk, it is actually talking about what, as a legal system, understand what are the risks. This is important to address because perhaps what we understand as a legal risk of EI is completely different from the technological perspective, it's completely different from the scientific perspective, it's completely different from the political and economic perspective. To put short, we have a problem of translation. It's not the same concept of risks. And this makes the debate of risk-based regulation problematic because what we perhaps want to discuss is the potential harmness of AI systems toward rights and not actually the risks of the technological development. So just to quote an important author, Rafael Di Giorgio, that says that usually society creates conditions to build different futures, to keep the contingency of events high, that is to say, to keep possibilities always open when due to a decision, an eventual damage was verified that one wanted to avoid and that another decision could have avoided. So, so it's important to remember that in a systemic view, the function of law, the stabilization of normative expectation, is always ex post facto and usually operates in the present, not in the future. So how we can understand this idea of risk-based regulations? Systems in general, from the perspective of the operation of system theories, cannot control the damage through risk. But the fact is, when the systems operate through risks, they produce new risks. There is an increase of risks paradoxically. So in this sense, I provoke, I question how actually the risk-based regulation produces new risks inside our legal system. Can we handle in legal terms, the risk that these kind of regulations presents? So in a book written by Luhmann in 1991 called Risk, a Sociological Theory, Luhmann admits its different form of the difference of the form of danger. It says, I quote Luhmann, a system self-observes only to determine which operation uses its own code and no other. To this end, the system must observe itself as an observer. So in this case, it is necessary to know who decides about the possibility of inputting the risk attribution decision in the risk-based regulation. This is a problem that we are facing today in Brazil. When we discuss the risk-based regulation, what kind of concept of risk we are truly discussing? Is the risk towards the rights, or is the risk towards technology? This kind of discussion, if we analyze the legislative debate, is problematic, and it's being used by different authorities and also agents in the process, and it's not clear how this will operate. But I believe that this is a necessary step if you want, in some ways, to protect the personal data in our country. So, just to end my quick presentation, I said a little bit quick. For sure, if you want truly to have a personal data protection, we need a legal framework of artificial intelligence in our country. Otherwise, I believe that our agency, Autoridade Nacional de Proteção dos Dados, will not have the sufficient tools in order to hold on accountable, especially digital platforms. So again, digital platforms also appear in this discussion of artificial intelligence. And I think all the debate that we are promoting here today also applies in the discussion of AI legal framework that is being discussed today in the Congress. Thank you so much.
Thank you very much, Marco. And I will open for questions so that we can use our time. Please.
So, good morning, everyone. Thank you for the exposition. And I was very reflective during the expositions, so it was kind of hard to formulate a question that was objective. But I've studied a little bit of Luhmann with Professor Villas-Boas, and he always said that to be integrated into all the systems is hard, but the disruption and so you can be disintegrated for all the systems is quite easy because they're all integrated. And it felt to me that during the pandemic times, we had the urge to be integrated with everything because without the virtual system, we wouldn't be allowed to go to the educational system because in our university we had distance classes. So my question is related to that. How can we deal with that limit of how we are integrated into societies and that we need to put our data into those apps and to be integrated? I'm being redundant here, but there's I wanted to mention a platform that we've studied in electronic commercial with Professor Portugal. That is a software named Bayesian improved surname geocode. It's BISG, if I'm not wrong. And it uses our location when we are using apps. So it can interfere and provide data to banks about our localization and about our sobrenome. I forgot the name in English.
Surname.
Yeah, our surname. And it gives the opportunity for you or not to have credit in banks. So my question is, how do we deal with what is offensive or not in that system, considering all the situation that we need to be integrated so we can access other systems? And that's kind of a question for all of you. So thank you.
I can start. So first of all, when we talk about systems theory, we have to make our first question is who is the observer, right? So when you make the question how we deal with what is the system reference you're talking about? Probably the legal system, right? So from the legal perspective, I think your comment is very interesting because the pandemic was very decisive on this moment, because as you put it out, we simply transferred our lives to the virtual relations system, right? The internet. And in this sense, in legal terms, we were not prepared to this situation, right? So probably in this moment when we shift to the internet, most of our activities into the virtual world, perhaps some let's say problems happened in legal terms, right? And you just gave an example of an application that operates with data, personal data, and you didn't even know about that, right? Concerning what we have as instruments in our country, Lei Geral de Proteção de Dados, our Personal Data Protection Act, would only focus mainly on the economic aspect of this, in terms of saying, well, this company should be held accountable because it didn't ask you, inform you in the first place that if you would agree upon these terms of using this personal data to third parties, selling to other companies, for instance. So, in this sense, the purpose of the accountability would be for economic purposes, but not from the operation of its system itself. So this is why it's important also to debate the AI legal framework, because the AI legal framework will improve the accountability in terms of the operation itself of this technology. So this is interesting because if we study the motives and the arguments when we pass the Lei Geral de Proteção de Dados, our Personal Data Act, we will see that the argument of artificial intelligence was never brought out by the legislator and by our community. So there is a gap, there is a big lack in terms of having the right instruments to deal with the complexity of accountability of these companies in our legal system today. So I guess you're right, when we talk about inclusion and exclusion in the system, from the perspective of the legal system, it's important to have instruments, or what Luhmann says, programs, right, to operate and to include situations that perhaps is not properly defined yet by law. So for us in Brazil, I believe it's important to have legislation regarding these issues. Otherwise, would be open for uncertainty even inside the legal system. So I don't know if I could address your question, but this is how I understand.
Just really briefly, I thought that was a very interesting example of how data and technology is leading to greater exclusion, inclusion, and it shows that the technology is way ahead of the norms on this and thinking normatively about this, it's far faster. So, thanks.
Just a brief comment. Luhmann deals with this topic of digital communication. He died in 1998, but he deals with this topic under the concept of means of dissemination of communication. So if you think that we are changing the means of dissemination from simple written communication to digital communication, we may be in a transformation so important that comparable to the transformation of a social life that was based on oral communication to a social life, a modern life based on written communication. So maybe law will also change its forms. So we are emphasizing here the importance of having national statutes on all these topics to put some limits, some liabilities, some obligations to the companies. But in fact, the risks will also be managed outside the national state, outside the written statutes and case law. And I think that the digital platforms, the digital companies will develop more and more legal private orders in order to deal with the risks and also to build a protection against the invasion of state law in those issues. So we cannot put state law, national law outside these issues, but we cannot also put the internal law of each of these teams, of these companies and sectors. Also, we need to deal with these private orders and to recognize that they exist and they will prevent some problems and generate other problems. Because I emphasize this sentence here on Professor Barros' presentation: risk control generates new risks. There is the self-regulation will generate new legal risks, and state regulation will generate new legal risks to each other. So we cannot foresee a simple solution to this. But thanks.
Hi, professors. I'm sorry, my English is not so good for a question. Assim, no Brasil a gente está vivendo uma situação bem caótica com a questão de ensino público. A gente sabe que existe uma discussão muito grande por conta do novo ensino médio. A gente não tem sociologia no terceiro ano. E eu sou professora de sociologia do ensino público. E tem sido uma situação muito complicada desenvolver esse pensamento de que necessitamos prestar atenção nas informações que colocamos na internet e no que receptamos dali. E é uma situação caótica, a gente sabe que tem várias questões para serem lidadas, mas para dar uma enxugada na minha pergunta, como nós, professores, e como nós, acadêmicos em geral, deveríamos começar a nos preparar para essa nova realidade. Porque a gente lida com o chat GPT todos os dias, com respostas prontas, então não tem um desenvolvimento no conteúdo. A gente passa uma matéria, passa uma questão, e isso já está acontecendo nas faculdades, tanto de direito quanto todas as outras, que você passa um conteúdo e você tem uma resposta pronta do chat GPT, uma resposta muito boa. E o problema aqui não é nem a questão ética, o problema aqui é a questão do desenvolvimento cognitivo. A gente vai ter um problema a curto prazo, né? E eu queria saber dos professores como vocês acham que a gente deveria se preparar para isso.
Would you like to translate?
I bit. She teaches sociology at the high school, mainly in public schools, and she's talking about how to educate people to use this kind of technologies and how to teach and to develop the cognition of the students. If they can put the answers, they can use the chat GPT to get the answers. The answers are good, but the cognitive abilities and skills are not developed. Well, just to comment on your question, 2 points. First, when we were researching in this project about fake news regulation, we were in a congress of sociology, not of law, and some presenters pointed out to the importance of having a digital education, so not only digital regulation. Of course, we are observing the teams with a view from law and trying to see what regulation should be put about these topics. But of course there is something prior to the regulation, which is the sense of how to use these technologies, and education is the leader of this process. I can only say about the sensation about the use of technologies in class. I think that we will need to separate in which activities we will have the support of technologies, in which research, in which kind of test, of exercise we will ask the student to conduct a research using those kind of tools, of digital tools, and we will have to separate a process of learning, a part of the course, to be maybe apart from the technology, and bring people back to read a book and to write an answer. Maybe we will need to separate and combine both sides, but having a part of the learning process protected from these impacts of technologies. People will need to learn how to use those technologies. They can be very useful, but maybe a part of the learning process we will need to return to the analogical way, to the more primitive ways of reading and writing things. This is a kind of sensation that we have in this moment.
I can only talk personally about this issue. I think personally, I think it's good that if students continue to use AI to write exams and write assessments, that maybe we can get AI to mark those exams and assessments, so that I personally don't have to do hundreds of scripts of marking anymore. Oh, you don't need it.
Thank you for your question. I think it's very important. First of all, I think we have to understand better what is the digital inequalities in our country in order to discuss what would be the steps that we have to move forward. This is a very big issue in Brazil. You know? When we talk about inclusion and exclusion, we are also talking about inclusion and exclusion in the digital system, if I could put it this way. As Lucas put it out, Luhmann died before the spread of the internet. And this is funny because when we discuss the idea of digital inclusion, we usually think towards the right to the connection, right? We say in Portuguese, o direito à banda larga, o direito à conexão. But there is no sense of defending the right to connection if we don't have the right of a digital education. So perhaps this is the case of debating the right of a digital education in schools. And I think when we start to analyze and understand the concept of the right to digital education, we are talking about, in some ways, understanding how these digital applications or how artificial intelligence operate, because it's not clear for society how they operate. And moreover, we are also discussing the idea that we do need to have ethical principles towards the use of artificial intelligence, the use of digital services. And for instance, I think this school, the law school here at USP, recently decided a very important, took a very important step towards establishing, right, Lucas could tell me better, an integrity commission regarding artificial intelligence, because this is an ethical debate as well. It's not a debate that should be controlled by the legal system, but perhaps by other communities or by other systems. In this sense, I don't think the easy way out to handle this problem that you mentioned is only through law. And you're very right. I think this is mainly a discussion about the operation of the education system. In my class, I am usually open for the use of technologies, but when it's the exams times, I ask them to completely stay away from technology. And this is funny because they don't know how to handle the situation. They don't know even to write. So this is very problematic. And we should debate this in an ethical perspective.
My question is related to this idea that you talked about of risk generating more risk. Not exactly in sociological terms, because I'm not, too knowledgeable in this topic at all, honestly. But it's from what I understand of your presentation, you suggested that we need a risk regulation on AI to make sure that data protection is actually enforceable and that it actually happens. My question would be regarding the economical risks that poses, because it seems to me that it's not only like big companies that use AI. AI is like honestly everywhere, like in smaller terms, and it's so I wonder if that's not a too big of an economical burden to place on companies, because risk analysis is hard, right? You're trying to predict the future. So if that's not a economical burden that is too big for example, national companies, and only bigger companies can really do this analysis and conform to our regulation, and then these big companies are the companies that have more data, and so they can combine our data, and so we are in a structural sort of manner just making sure that only big companies take on these spaces and produce AI. And I think part of the risk of involving data protection is not just the use of data, but how big the companies are that are using this data, because they can then combine this data, right? And so sort of my question is this kind of regulation not reinforcing a system where there are big companies that can combine data and then just not misuse them? I think if that is clear at all.
Okay. So thank you so much. It's a very interesting question, because it put forward the discussion about what is the risk regulation and what are the relations, for instance, with the economic perspective. And I guess you're right. When we establish Lei Geral de Proteção de Dados, General Protection Data, similar discussion appear. I don't know if you are aware of that, because in our General Data Protection Act, there are lots of obligations that the company must attend, and some of them are, for instance, each company in Brazil has to have a data protector officer, right? Each company has to do mandatory reports and establish an information security system. That if we compare the size of the companies, for sure, this would be
a problem of inclusion and exclusion in the market, right? And the solution that our national authority, Autoridade de Proteção de Dados, created was to mitigate, to in some ways, I would say flexibilizar, to flexibilize some of the obligations when we talk about small companies or micro e pequenas empresas, right? I guess perhaps towards the idea of risk-based regulations, something might be also on this equation. For sure, the main responsible for data protection violation in our country that use AI systems are big companies. This is the main goal. They want to regulate in some ways the digital platforms, not the small businesses, right? So in this sense, I believe that we should also be debating some perspective of inclusion of small companies in this kind of market. And perhaps if we have an independent agency for AI, and this is the debate that we are also discussing in the Congress right now, perhaps the independent agency could draw a line of who will have the responsibility, which kind of companies classified by their size, and others who could be, you know, flexibilized towards this obligation. But this is not clear, you know. But your question is very good. And another issue that you mentioned is the competition aspect of this, because we are talking about the possibility of entrance of new agents in the market. Would this regulation be another barrier for the entry for the market? So it's precisely because of this discussion that CAD, Conselho Administrativo de Defesa Econômica, our antitrust agency, is also concerned about this legal framework. What will be the impact regarding our competition law? It's not very clear yet, but you're right.
Sorry.
I also wanted to thank you, Marco, for interest in presentation. And I was thinking that in a way, there's a common theme here today, is that, you know, who has the right to decide and who represents society, I think is across the board in what we talked about. But when you were talking about AI and risk, I was thinking, I'm not sure if you heard, but somebody who worked on AI at Google for many years recently resigned, and he wrote an op-ed about this, and he discussed the reasons why he resigned. He said it was getting scary, the development of the technology. And it made me think, you know, the book Risk by Luhmann is actually probably one of his least original pieces of work, because it was not his idea. It was Ulrich Beck, the German sociologist, who really came up with this. And the basic idea is that society, you know, if your house burnt down 200 years ago, it was an act of God. But because technology develops, if this happens today, it's somebody's fault. Somebody made the wrong decision. And what's interesting about AI is that kind of it's getting to the stage now where we're not going to make the decisions anymore. A robot is going to decide, and in a way we're back to, we won't have anyone to blame but the technology itself. So not really a question, but a comment I'd throw in there as an added layer of complexity on this interesting subject.
Talking specifically about the AI regulation draft, the text offers like a list of examples of high-risk applications based mainly on the domain of the application, right? My question is very briefly in the sense that, is this a proper way of handling risk, for example, in the legal aspect of risk? Is the domain of application a good classifier of risk? And also, if there are relevant differences that need to be addressed by law of AI applications in the public sector and in the private sector? Thank you.
Perfect. Yeah, that's the discussion that I mentioned in my presentation is the idea of establishing a list of authorized and not authorized sufficient. And when we establish a list, perhaps these domains confuse the risk of technology and the risk of law. You know, we don't know exactly by just looking by the domain if you are discussing technology or law or rights. You know, so this is problematic. Another question is this an open-ended list that, you know, technology itself develops that we could use in terms of just as a paradigm, or this is a closed list, only these situations would be authorized or not? So there are a lot of critiques regarding definition exclusively by list. Perhaps the list would be only illustrative, and actually what we would depend is the real work done by the agency when they define the cases, right? And I guess you're very right as well when we talk about the use of AI in public sector and in private sector, because the interests are different. When we talk about private sector, perhaps this debate of market is more present. And when we are looking about the public domain, we are mainly concerned about our civil liberties, and perhaps the way of regulating the public should be different when we concern the aspect of the market. I think that our bill proposal lacks proper debate about the public domain, and we should be worried as well. So, just to keep in short, I'm not very optimistic to regulation only through the list, and I think that the main problem today is this overlap between risk of technology and risk of offense of rights that is not very clear in this list. For law, the concern would be mainly the offense of rights. You know, this is what law can communicate about. So we should, you know, promote more discussion regarding what kind of rights we are concerned, what would be the possible tools that the legal system offers us to handle, you know, these risks.
Mais alguém? Últimos minutos.
Bom, se não tivermos mais nenhum comentário, nenhuma pergunta, I want to acknowledge again Professor Hanna, Professor Barros, and you all for being with us this morning. And I want to invite you all to take a picture. Let's take a picture of all of us to register this moment.